So this is another video here in the series on trauma in probate proceedings, and I wanted to try and share some insight on how I think judges view trauma in probate proceedings. Probate judges are unique and special kind of judge wearing that black robe because it is a cauldron of emotions. It's a cauldron of conflict. Different than family law, certainly much different than criminal law. In law, we say that family law is good people on their worst behavior, and in criminal law, it's bad people on their best behavior. I think in probate, it's good and bad behavior in people just expressing themselves in dysfunctional ways in those high conflict probate situations. Now, the perfect probate is mom, dad, grandmom did their estate planning. They've got good explanations and rationale. The information is laid out there properly. It's done correctly, and things just move along. But the high conflict probate situations are almost always marked by trauma by one or more, and oftentimes all of the parties. And I will say this over and over again, high conflict probates almost always have elements of alcoholism. I would venture to say that the incidence of alcohol not being involved or not being a primary factor in conflicted probates is going to be real small. But how judges experience this starts with the very first pleadings. I mean, the reality is in the easy probates, judges don't see much anything. We process the paperwork. Everything's laid out correctly. Clerks largely handle the stuff. If there's lawyers on the other side, we're kind of checking each other's work and negotiating things out. And in the vast majority of cases, that's what helps a probate move along quickly. But in those instances, and the instances are dramatically increasing of conflict probates, adversary proceedings, how those issues are framed up, brought to the judge's attention, speaks a lot to how the dysfunction within that family manifests itself in the probate. I think probate lawyers in particular are mindful in a way that maybe our brethren and sistren in the family law world are as well, of our duty to kind of navigate these waters, to smooth over the rough edges, and to get these people on the other side of this probate as quickly as possible. But again, there's this dynamic in probate of conflict that is absolutely increasing within courtrooms. We see it in, modest estates where lawyers are piling in, and instead of siblings or whatever else just being able to settle out this couple $100,000 million deal or whatever, they're fighting among one another. Particularly in the big value estates, the conflict just gets wrapped right up. And because there's lots of money to fight over, lawyers are making money and people are losing money. Sometimes they just don't care. That's how deep the trauma is. That's how deep the conflict is. But an essential element of conflict probate practice has got to be understanding the trauma, understanding the trauma that exists, and at least getting on the table. Sometimes they can work through it. Oftentimes they can't. The probate was not the place to do that fully and finally, but if you're mindful of it, it can really help to move things along in a much more efficient manner and in a way that respects people and is efficient, costs less money. But what are the tools that judges have? Judges do have some very specific tools that they use and deploy with increasing frequency to help moderate and resolve these things. Key among them is mediation. Mediation can be like a therapy session, particularly in this world. I know of the only mediators I want to use, quite frankly, are judges. If you've got decades sitting on a bench hearing all kinds of cases, that's who I want you in the probate case to be mediating. I don't want somebody that was not a judge. Arbitration, again, a way to narrow down issues, get it resolved before the judge has to make decisions. Case management orders. Increasingly, judges are cracking the whip, bringing people in. Just as I've done throughout my entire practice, I drag the clients in with me. Much of this stuff is done by Zoom still, so there's no excuse for clients not to be there in these meetings where lawyers are getting called on the carpet for not moving things along. The clients can hear that. I think that's perfectly appropriate. Increasingly, judges are relying on curators and ad litems to jump in In some cases, that becomes the neutral, if you will, the Switzerland. While the parties down here are fighting and warring, we got somebody in the center that can help to kind of smooth things over. But the bottom line is this. Judges are increasingly attuned to the issues of conflict and probate. We need to understand that as practitioners. We need to provide the tools to judges of what we think can help move us past this conflict. And sometimes this means, suggesting mediation as an alternative. Sometimes this means lawyers getting together and carving out specific areas or specific issues. If we got 5 warring parties and the real conflict is over these two, we may have to peel these two out and fight over one particular issue, the homestead property that this one wants or whatever, and kind of get them out of the way as a way of narrowing down disputes in a way that doesn't embroil all the other ones. But the bottom line is this: understanding what this is critical, and then what tools are available to the judges to resolve these things, particularly this concept of curator, ad litems that can pursue litigation, and then the mediation, arbitration, and other formal alternatives to getting this stuff resolved quickly and efficiently.